Oh yeah, I think that's fair to say.
Good. This is the time set for oral argument in Heritage versus ADHS, CV19 0399. Counsel, we have reviewed the record. We've conferenced the case. We'd encourage you to keep that in mind as you present oral argument. Each side is given 20 minutes to present. If the appellant wishes to reserve a portion of that time, you can do so, but you need to keep track of your own time. And please, given the environment, and I'm on by phone, we're being recorded as well, but announce who you represent as you begin your comments. So with that, Mr. Purcell.
Good morning, Your Honors. Jimmy Purcell on behalf of Heritage Carefree, the appellant. I would like to reserve some time, but as you suggested, I'm keeping track of that on my own. This case is fairly straightforward when stripped of many of the factual arguments that the parties have been engaged in. At the core is the interpretation of AAC R910803G1, which provides that a manager shall not act as a residence representative and not allow an employee or a family member of an employee to act as a residence representative for a resident who is not a family member of the employee. The lower court, as well as the department, found that the mere designation of one of these prohibited persons is sufficient to trigger a violation of the statute, as opposed to requiring any kind of act in that capacity. In reaching the conclusion that that was sufficient, the lower court, the Superior Court on Appeal, basically agreed with that assertion or that finding on the grounds that to hold that an actual act was required leads to an absurd result, which brings us really to the core issue here. In the appellant's position, this regulation, this rule, is clear and unambiguous on its face, and it requires an act. The findings below were that the violation was appropriate with regard to resident A, and it's the court will probably recall there are two powers of attorney that are at issue here. The first one was entered into in 2014, was essentially in offsite storage and discovered during the on-site inspection. There's no dispute that it was ever acted upon. The only basis for that violation was the fact that it existed in and of itself.
But who had the right to act on behalf of the patient?
I'm sorry, Your Honor. That question is susceptible to a couple of interpretations.
Let me make it clearer then, since we're even debating the meaning of the word act. One human being held the power of attorney, yes?
Correct. There was
the only human being, therefore, empowered to act on behalf of the patient. No one else.
I disagree with that, Your Honor.
Who else was empowered?
The resident herself.
Well, okay. That kind of defeats the whole purpose of these powers of attorney, doesn't it?
No, Your Honor. The power of attorney.
What if the resident is incompetent at the moment? What if the resident is suffering from a disability that prevents him or her from acting on his or her own behalf? The only person left to do it is somebody who is barred from doing it. Is that not correct?
That is not correct, Your Honor.
Okay, why not?
363201, and we have to work our way through a number of these statutes and a number of the regs in order to get
before we work our way through statutes and regs, can you tell me who was authorized to act on behalf of the resident?
Any form of surrogate, Your Honor, which is somebody that can be, by statutory definition, can be a close friend, it can be another relative. It doesn't have to be someone that is...
So a close friend without a power of attorney can act on behalf of the resident? That would be extraordinary. What if two close friends disagree on the course and they both show up and say, I'm a better friend than you? I mean, you need a document, don't you?
No, Your Honor, not according to 363201, which then leads us into define surrogate. And if Your Honor will give me just 1 second, the definition of surrogate is contained in 3632331, and this is all.
Wait, give me that site again. I'm going to look it up as we talk.
ARS 363231.
Okay.
And this statute defines surrogate decision makers. And these are the decision makers that are allowed to make medical decisions for the adult patient if the adult patient is unable to make or communicate healthcare treatment decisions. And if you, before you get here, what you'll find is a statute that has power of attorney or some other surrogate. And this is all leads back to the
so basically, you're saying this entire power of attorney was just a complete nullity. It was irrelevant to the patient. It was never going to be exercised, and they could always go out and find a friend if they needed some help. Is that the idea?
That would be correct, Your Honor, under the statutory scheme. But
okay, then why have the document at all? Why would a member of your client's organization even accept such an assignment if it could never be exercised and they were just going to go on the street and find some friends anyway?
The issue here, Your Honor, is that it would be a nullity. It would be something that the entity, the assisted living facility, couldn't operate under, because to act would be a violation.
Yet on multiple occasions, your client took these powers of attorney on. And now you're saying that they were all nullities. Why would they do that?
Your Honor, in the first instance, the 2014 one was a backup power of attorney. It also never became effective because these medical POAs...
Really answered the question I asked you. The question I asked you is, why would they do that?
In the first instance, Your Honor, Ms. Holbura simply accepted that to put in the file because the resident asked her for that, and she didn't want to be rude. She thought it was endearing. That's what the briefing in the court below and the administrative agency below found. In the second case, subjective feelings about endearing behavior aside, though, as a licensed actor, why would they do that? Why would they do something that is plainly legally problematic and likely in violation of the regulations? They would do that just because conduct was endearing? In this instance, that's the statement that Ms. Holbura has made. In the second instance, I think it's important to realize, Your Honor, in the second instance, that POA never made it into my client's records. They had no knowledge of the second POA until it was brought to their attention. It was signed, and this POA is not one, incidentally, that my client was the POA. This is the Miss Mikey, I think is the pronunciation. And this illustrates the issue with the department's interpretation of this reg, is that in that instance, this was entered into, signed by the purported POA, Miss Mikey, at Banner Hospital when the resident was in Banner. That when the resident was admitted to my client's facility, Banner transmitted initially no paperwork came over. Banner faxed 10 pages of medical records. The POA wasn't there. Banner faxed the POA to APS as part of one of their investigations, but my client didn't become aware of it until after the fact and until the citation was being issued. And Your Honor, I think that illustrates why this interpretation that requires an act before there's a violation. Your Honor's question is perfectly valid. Why would the institution, why would the facility accept it if it can't be acted upon? There's no reason to do that. But that's not the question here, Your Honor. The question here, Your Honor, is whether or not that alone is a violation that allows the imposition of a civil money penalty.
Well, I mean, I think there's a problem with the premise of your question, though, or of your position. You're saying, why would they take something that could never be acted on? The could never be acted on, we can agree here now in the calmness of an appellate proceeding that it wouldn't have been a good idea to act on it. But as a practical matter, there was no impediment to being acted upon at all. I mean, and if it had been, obviously this would be a much more serious case, but there was no reason that it couldn't have been acted on.
I would agree with that, Your Honor, but that concern...
By virtue of your client's conduct. So I don't understand where you find comfort in the language of the statute or regs.
Because it requires, on its plain language, on its face, an act. And that's the line that the department has chosen to draw as to when liability...
It doesn't say an act. It says acts, the present tense, the verb act.
Correct.
Not an act.
Correct.
And one is, so I imagine that you and I probably both have Michael Bosco as the trustee on our home mortgages. Is Michael Bosco acting as trustee?
Your Honor, I think that's a different definitional issue when you start talking about...
There's no statute in play here. I'm asking you for a plain meaning, common understanding of the words. Is he acting as our trustee on a deed of trust, even though we have not been foreclosed upon?
Your Honor, he's been designated as the trustee. Whether or not he's acting as the trustee, I would assert, depends upon whether or not he does anything in that capacity.
So the mere fact of accepting being the responsible party under the power of attorney is not acting?
No, Your Honor, it's not engaging in any conduct that affects the resident. And I think we keep focusing on the first one. I think the second one, the Mikey one, is the better example. Under the interpretation by the department, if somebody designates my client as POA and my client never learns of it, in the instance with Miss Mikey, it was entered into at Banner, it was transmitted to APS, and it didn't get into my client's files, wasn't transmitted to my client until it was brought to our attention by the department. And if that's enough, if the mere designation is enough, then we're going to have these sorts of cases where you have pages and pages talking about, well, should we have known? Should we have known? Should we have looked at records? Should we have done more than just inquire to determine whether or not we've been designated? When in actuality, if you simply interpret the statute as written, that they shall not act as a POA or allow someone to act, and that requires the performance of some function, then there's a bright line test, and we never have to get into these other issues, such as is there knowledge that there's been a designation?
Well, let me ask you this then. Let's say we have an unscrupulous facility that is taking these POAs with every intent to act on them. Okay? I'm not saying that's your client. If the unscrupulous facility acts on the POA, it is clearly committed a violation, right?
Correct.
And if it does that 10 times, it's committed 10 violations. But if it has 90 additional POAs that it just hasn't acted on yet, that's okay?
The 90 additional POAs wouldn't be a violation, but the 10 acts pursuant to
the unscrupulous facility that has harmed people in this hypothetical, unscrupulous facility is taking advantage of people, harming people on a routine basis, and yet we're going to say that the regulations say it's completely fine for them to continue gathering these POAs.
Absolutely not, Your Honor.
Seems like a stretch to me.
Absolutely not. What Your Honor's overlooking in that analogy is that those first 10 are going to result in the facility being revoked by the department.
Or maybe just fined to the tune of a very small amount of money, as happened in this case.
Well, in this case, Your Honor, as you recall, there's no harm, there's no evidence that any action was taken pursuant to these POAs. One was in the file, never acted upon for 3 years, sitting in off-site storage. Very little chance, I would assert, of it ever being acted upon. And the other never made it into my client's files, and the department wants to argue with regard to whether or not they were on constructive notice because there was a POA question mark in the file. In your example, there's a series of egregious acts where there are actual statutory violations that allow the department to take action. Yes, Your Honor?
Counsel, so there's no violation unless you get caught at it then?
Well, Your Honor, no, there's a violation if you commit an act. Whether or not you're caught at it is a different question, and whether or not the department finds out, the same can be said even if you punish mere designation. Under that scenario, there's no violation unless it's found. I think here there's a bright line test that doesn't lead to an absurd result, and I don't think we get to go outside the scope of the plain language because there's this idea that the department wants to be able to punish prior to any action under the POA.
Well, I guess I don't understand why the facility accepting the designations is not an act.
I would assert, Your Honor, that accepting the designation, bearing in mind that we don't really have that in one of these two instances here where there's been a violation that's been found, would not be an act under the statute, because I think, again, where it's directed is taking some action pursuant to the POA. They haven't.
But counsel, in the Mikey example, Ms. Mikey accepted the designation. The rule does not allow a family, someone connected with the facility to act under the POA, and if they've accepted it, wouldn't that also be an act that violates the statute and the rule?
But that then leads to the issue of the manager's not allowed to allow the person to act. Well, there's no way that a manager can allow or disallow anybody to be designated as a POA if that's done off-site without the facility's knowledge and they don't have any reason to know. And that's why, it's our position that what should be punished is if that POA is acted upon as opposed to the mere designation. Under Your Honor's view, if the designation occurs outside the facility with no way of knowing about it, then the employee accepting the POA is thus an act, and we can be on the hook for that when there's no knowledge, there's no wrongdoing, no intent on the part of the facility. And Your Honor, unless you have another specific question, I've got about 2.5 minutes left. I'd like to reserve that amount of time.
Sure.
Good morning. Can you hear me?
Yes. Let me make sure Judge Thumma can hear you. Judge Thumma, are you there?
I can.
Okay, great.
And I'm going to try to rejoin via Skype, but go ahead.
Okay. We're ready to proceed.
Okay, I'm just going to reset my clock. Okay. Good morning, please, the court. My name is Patricia Lamagna. I'm Attorney General that represents the Arizona Department of Health Services. This court should affirm the decision below because there's, yes. Counsel,
your audio is cutting out, but I sense that it's only because you may need to speak a little louder. I think there's a threshold below which you're falling.
Okay, I'm going to turn the volume up a bit.
That helps already.
Is that better, Judge?
That seems pretty good to me.
Okay, thank you. This court should affirm the decision below because Heritage violated the rule that prohibited the employee or employee's relative from acting as a representative for residents in the assisted living facility. As the court, in the court's discussions with counsel for appellant, the court is correct that affirmative action is not required for the rule to have been violated. Appellant's arguments regarding the clear and unambiguous language and the statutory interpretation are simply incorrect. They ignore the holdings by the Arizona Supreme Court in Bilkey and mailboxes, etc., just for two examples, where the whole aim of statutory interpretation is to effectuate the legislature or the individual who wrote the rules. And so while it is true that a statute or rule, if it's clear and unambiguous on its face, a court can decline to go further in statutory interpretation. But that's unless the application of that rule or statute leads to an impossible or an absurd result. In these particular cases, the department's interpretation of that rule is based on the entire statutory scheme and the goal here, which is to ensure that residents in an assisted living facility are protected. For the rule to be interpreted as suggested by appellant means that you're putting those residents in harm's way on a continual basis. So,
counsel, let me ask you, wouldn't it have been better for this reg if it said to hold as opposed to act? Wouldn't that have largely resolved the issue? Would we be here if it used the word hold instead of act?
Oh, perhaps we would not be here. I can't speak to that in particular, but this particular rule and the way it's been applied has been effective for many years, and there are thousands of assisted living facilities and other healthcare institutions that are able to understand the department's interpretation of this, and they avoid the situation that Heritage is in now. When you
say this is the way it's been applied, you're talking about the way the department has applied it?
Yes.
Please tell me you're not suggesting that Arizona has a little mini Chevron doctrine.
Oh, no, Your Honor, not at all.
Good.
I'm really speaking to the argument that appellant makes regarding whether or not they knew and had prior knowledge that the department interpreted this rule and applied it in that way. That the record does not support that. In fact, the fact that Heritage had an initial violation of the rule and 6 months before the secondary violation of the rule certainly put them on notice regarding this particular rule and the actions that they took that were prohibited under the rule.
Counsel, how do you answer the concern about the rogue employee who is designated on POA, POA without any knowledge of the facility?
Well, Your Honor, the record does not support the fact that Heritage did not know or should have known that Mikey was designated as the POA for Resident B. The records for Resident B, the medical records, contain multiple instances where Mikey is listed as a friend / POA. There is a question mark next to that. It's clear that the facility had some knowledge that Mikey was acting in that regard. Also, there's evidence in the record that Mikey was assisting this particular individual to get into the facility because her mother did work there. So,
okay. Go ahead.
Counsel, what would be the result if the facility did not know? If you truly had a rogue employee, would there be no violation at that point?
If the facility did not know and had no way of knowing, and the facility was following all of the policies and procedures to ensure that its employees understood that to be the case, then presumably there would not be a violation. Because without the knowledge, that certainly the department can't hold a facility accountable for something that they didn't and could not have known about. But that's not the facts in this particular case for the Resident B and Miss Mikey.
Thank you.
Mm-hmm.
Counsel, let me ask you. I mean, I understand you're going to say that these aren't our facts. Okay, so this is a hypothetical. But if you have a facility in which, say, there's one exceptionally charming care provider who befriends many of the patients, and they, on their own initiative, create POAs, never deliver them to the care provider, but for whatever reason they just all create their OPOAs naming this lovely person. Do we have a violation?
Well, I think it would, sorry, let me ask you, I'm not sure exactly about the facts of your hypothetical. So are you saying that the individuals create the POAs and then they keep them themselves, so there's no way for the facility to know?
Well, they keep them in the drawer in the nightstand, just in case they're incapacitated. Then there will be a document there, and they don't really share that with the care provider. But this person is so inspirational to all the patients that they say, "I want you making my decisions." And so you've got half a dozen people with POAs in their drawer naming this person. Do we have a violation?
Well, perhaps, Your Honor. It would depend, I think, on
that would be
the
very
facility's
scary,
training.
wouldn't it? That would mean presumably that somebody could just tweet out that I have their power of attorney, and I'm suddenly in violation. I mean, there has to be some voluntary conduct by the facility, doesn't there?
Yes, and the conduct on behalf of the facility can come in different ways. It can come with the fact that they haven't been training and facilitating or supervising their employees in a way that lets them understand that this behavior is not acceptable and dangerous and a violation of their regular.
Under my hypo, there was no behavior except providing top quality care that inspired the patient.
Well, then presumably in your scenario, there wouldn't be a violation.
And why is that under the language of the statute?
Because the rule says that an assisted living facility will not allow an employee or an employee's relative. So it comes back to the allow language in that.
But the employee, neither the facility nor the employee even knows it happened. How could the facility have done anything differently?
Well, it would depend, I guess, on the. So when I answered your question about if they had no knowledge and couldn't have had knowledge that was occurring, it wouldn't be a violation. It would only be.
I understand that's your position, and it's a just position. But what I'm trying to do is reconcile the necessary concession you make on this hypothetical with the language of the statute. Because while we can argue about what's in the record, and we will certainly comb through the record very carefully, the question remains. You know, if the characterization is correct that this was just patients acting on their own, the facility had no knowledge, etc., how can we say that they are acting if, under my hypothetical, we say they are not acting?
Well, if the act is accepting that power of attorney and accepting that position, then the employee is acting as that representative in your scenario. But then it goes back to what's the connection to the facility itself?
Okay, so saying that acting happens when they accept the appointment, right?
Correct.
Okay, not when they're named, because that could happen in a vacuum, but when they accept the appointment. So what do we have in the record here to show that the appointments were accepted?
So I'm sorry, if you'd let me go back, Your Honor. So it's in the scenario that you gave me, was the employees accepting, that employee presumably knew?
No, my scenario, the POA went in the nightstand drawer and the employee knew nothing. But there's still POA. Well,
the assuming of that role, yes, I guess there would be when you take that scenario, that you're hypothetical, that the accepting of the POA is certainly an act, because then you're in the position to make those decisions on behalf of the individual.
Well, go ahead, finish your answer.
Well, because of that's not
I was just going to say.
I apologize. That's how I understand Judge Swan's hypothetical. The employee does not know at all. No one knows. So is there a violation there or not? There's really not an acceptance at that time, is there?
No, Judge, there wouldn't be an acceptance if the employee did not know about the designation.
Is that really the issue, that there was an acceptance, or is the issue more that you're implying some sort of scienter requirement into this statute?
No, I think it comes down to a couple of things. Accepting, I don't think we're adding anything into the way that the language of the statute, or implying that. It comes down to, in the particular case of Heritage and other facilities, the department looks at, when they discover that this has happened, they do look at the situation to see. So, for example, as soon as Ms. Holborough knew about the powers of attorney that have been, where she had been designated to act on behalf of this resident, which, by the way, the healthcare power of attorney was not a durable, but the financial power of attorney was durable. So since 2014, so for about 2.5 years, she had an active financial power of attorney over that resident A. But that being said, once she knew about them, she needed to do something about it, and she didn't. And once they had the facility understood or had even constructive knowledge that the second resident had those powers of attorney that were designated as person who was an employee's relative, they needed to do something about it. They didn't do anything about it.
I understand that, and that sounds again like you're saying there's basically a scienter requirement, which may be a reasonable position, but as we look at the language of the statute, I guess I'm troubled by the notion that we're starting to talk about acceptance as an act. We don't need an act. The statute says anyone who acts as. So is it your that position then that if you knowingly hold a durable power of attorney, you are now acting, but if you don't knowingly hold it, you're not acting? Because if that's your position, it's very reasonable, but I just don't see express language for it in the statute.
Well, I think that has to be the department's reading of that statute, because otherwise, go back to your scenario. If there's no way for the facility to know that this has happened, and does that mean that they can be held responsible for violating this rule? And that certainly would be a difficult position for the department to take, because then that would leave the assisted living facilities at a loss to go beyond what they.
You're making a ton of sense in the abstract. I'm just trying to square it with the language of the statute, and I'm having difficulty doing that, because it is possible to act without knowledge, right? I mean, if you break something in your sleep, you acted to break that object, but you didn't have knowledge that you were acting that way.
Well, that's true.
So the word act itself does seem ambiguous in this context, at least if you want to read it the way you're suggesting.
So, well, we can, if the word act seems, you're saying it seems ambiguous. So if it is ambiguous, then you have to look again at the entire, how is an act, the term act, used in other contexts. So acting as, in different statutory sections of under Arizona law, there is some language where they use that act as. And for example, sorry, I need my glasses. For example, when someone is designated as, there's an affirmative designation, and that is an acting act that allows someone to act as a representative. The statute I'm looking at is 4-222A. That's just an example. I believe that the department's position does square with the language of the statute. Now, and I also believe that.
Just love you to walk me through that.
Well, because the department, the rule says that a facility may not allow. So the allow language is in there, which that's the prohibition, that they have some knowledge of the of the act itself, the designation itself. So another scenario would be if a facility knows that a POA has been designated for someone who's an employee or employee's family member, but the individual doesn't know that they have been designated, that still could be a violation, because then the act has occurred and it ties back to the allowing of the facility to have that happen. So I'd like to address a couple of other arguments that appellant makes. Just very quickly, the abuse of discretion argument. In this case, they make the argument that the director's decision and the civil money penalty assessment is unreasonable. And that is not true. ARS 36341.0A allows the director great discretion.
Hey, let me stop there. You're starting to cut out again. Can you speak up?
Sure. Can you hear me now?
It's better.
Yeah.
ARS 3641 allows great discretion in assessing civil money penalty. In this case, she was her discretion to assess the first civil money penalty and also the 2,200 money penalty. Also, I would like to just touch on the argument that appellant makes about the notice in the case that they were, I think actually I did already touch on that. The department or the appellant relies on the fact that they claim at the very end of their argument that they didn't know. They couldn't have known this is how the rule was being applied. But again, that the facts do not support that. They did have knowledge of this before all these events occurred, and certainly they had knowledge after the first violation. But they made it to choose not to correct. So unless there are other questions, I'm sorry, my clock timed out. I will again ask the court to please affirm the decision below, and I appreciate your time.
Thank you, counsel. We appreciate it as well. I apologize to all of you. Neighborhood internet service provider conked out, and so I'm patched through in different ways, but that's why I joined sort of midstream. Mr. Purcell, I think you have about 2 minutes and 30 seconds in rebuttal.
Yes, Your Honor, that's what I show as well. I think that there are a number of points that need to be hit in response to the appellee's arguments. With regard to the case law that's being cited with regard to absurdity, which I think clearly indicates the fact that they're relying on absurdity, to me is an implicit concession that we don't fit within the literal language of this statute. Mailboxes, etc., for example, is a case where an individual who was self-employed, he had a sole proprietorship and paid into the workers' comp fund, and then when it came time for him to apply for disability, the statute was interpreted to mean earned income was the equivalent of his wages. In other words, since his business was losing money, he never got a wage and therefore he wasn't entitled to anything. That's an absurd result for somebody who's been working consistently and has been paying into the fund, that there was another manner in which wages could be calculated that the court found was a more reasonable way. Another perfect example would be the Walgreens case, where they talk about whether or not return of principal is considered gross receipts. I guess the plaintiff in that instance, or the non-governmental entity, was essentially trying to count the return of principal on an investment as gross receipts in order to artificially inflate quote-unquote sales. That was an absurd result. Here what we're dealing with is simply the idea that there's one interpretation that is logical, it's on the plain face, that requires an action. That's a bright line. If you do something pursuant to a POA, and again, Merriam-Webster defines act as to take an action to perform a specified function or to produce an effect. None of those happened in this instance, and that illustrates the problem with the state's position, that if you limit it to performing a function or taking an action, then you don't have to go into whether or not there's a knowing action or an unknowing action, what it means to allow that sort of thing. The plain language is unambiguous, and the court should enforce it as written. Thank you.
Counsel, again, with my apologies to everyone, thank you for your presentation. Thank you for your briefing. We'll take the matter under advisement, and we'll issue a written ruling in due course. Court stands adjourned.
Thank you.
Thank you.